Jurisdiction of Sharia District Courts. Sharia District Courts have exclusive original jurisdiction over all cases involving custody, guardianship, legitimacy, paternity, and filiation arising under the Code of Muslim Personal Laws of the Philippines. The Sharia District Courts have exclusive original jurisdiction over all cases involving disposition, distribution, and settlement of the estate of deceased Muslims, probate of wills, issuance of letters of administration, or appointment of administrators or executors, regardless of the nature of the aggregate value of the property. The Sharia District Courts have exclusive original jurisdiction over petitions for the declaration of absence and death and for the cancellation or correction of entries in the Muslim registries. The Sharia District Courts have exclusive original jurisdiction over all actions arising from customary contracts in which the parties are Muslims, if they have not specified which law shall govern their relations. And the Sharia District Courts have exclusive original jurisdiction over all petitions for mandamus, prohibition, injunction, certiorari, habeas corpus, and all other auxiliary writs and processes in aid of its appellate jurisdiction. Concurrently with existing civil courts, the Sharia District Court have original jurisdiction over petitions by Muslims for the constitution of a family home, change of name, and commitment of an insane person to an asylum. All other personal and real actions not mentioned in paragraph 1d, wherein the parties involved are Muslims, except those for forcible entry and unlawful detainer, which shall fall under the exclusive original jurisdiction of the Municipal Circuit Court, and all special civil actions for interpleader or declaratory relief, wherein the parties are Muslims or the property involved belongs exclusively to Muslims. The Sharia District Courts have appellate jurisdiction over all cases tried in the Sharia Circuit Courts within their territorial jurisdiction. Jurisdiction of Sharia Circuit Courts. Sharia Circuit Courts have exclusive original jurisdiction over all cases involving offenses defined and punished under the Code of Muslim Personal Laws. The Sharia Circuit Courts have exclusive original jurisdiction over all civil actions and proceedings between parties who are Muslims or have been married in accordance with Article 13 of the Code, involving disputes relating to marriage, divorce, betrothal or breach of contract to marry, customary dower, disposition and distribution of property upon divorce, maintenance and support and consolatory gifts, and restitution of marital rights. The Sharia Circuit Courts have exclusive original jurisdiction over all cases involving disputes relative to communal properties. Let's discuss some cases. The Sharia Appellate Court and the Office of the Jurisconsult in Islamic law must now be organized to effectively enforce the Muslim legal system in the Philippines. The case of Villagracia versus 5th Sharia District Court, GR number 188832, April 23, 2014. The facts in this case are as follows. Petitioner filed directly to the Supreme Court a petition for certiorari of respondent 5th Sharia District Court's decision. Now, the issue in this case is which court has jurisdiction over petitions for certiorari of decisions of the Sharia District Courts. The Supreme Court held that under the judicial system in RA number 9054, the Sharia Appellate Court has exclusive original jurisdiction over petitions for certiorari of decisions of the Sharia District Courts. The court held that the petitioner should have filed his petition for certiorari before the Sharia Appellate Court. However, the Sharia Appellate Court is yet to be organized. Thus, the Supreme Court called for the organization of the court system created under RA number 9054 to effectively enforce the Muslim legal system in the country. After all, the Muslim legal system, a legal system complete with its own civil, criminal, commercial, political, international, and religious laws, is part of the law of the land, and Sharia courts are part of the Philippine judicial system. The Sharia Circuit Courts and Sharia District Courts created under the Code of Muslim Personal Laws of the Philippines shall continue to discharge their duties. All cases tried in Sharia Circuit Courts shall be appealable to Sharia District Courts. The Sharia Appellate Court, created under RA number 9054, shall exercise appellate jurisdiction over all cases tried in the Sharia District Courts. It shall also exercise original jurisdiction over petitions for certiorari, prohibition, mandamus, habeas corpus, and other auxiliary writs and processes in aid of its appellate jurisdiction. The decisions of the Sharia Appellate Court shall be final and executory, without prejudice to the original and appellate jurisdiction of the Supreme Court. So in this case of Villa Gracia, the Supreme Court cited Tumawis versus Honorable Balindong that until such time that the Sharia Appellate Court shall have been organized, decisions of the Sharia District Court shall be appealable to the Court of Appeals and shall be referred to a special division to be organized in any of the Court of Appeals stations, preferably composed of Muslim Court of Appeals justices. However, considering that Tumawis was not yet promulgated when Vivencio filed his petition for certiorari in August 6, 2009 in this case, the Supreme Court took cognizance of the petition for certiorari in the exercise of the original jurisdiction over petitions for certiorari of the Supreme Court. The Supreme Court held that priority should be given in organizing the office of the jurisconsult in Islamic law. A jurisconsult is, in Islamic law, or mufti, is an officer with authority to render legal opinions or fatwa on any questions relating to Muslim law. These legal opinions should be based on recognized authorities and must be rendered in precise accordance with precedent. In the Philippines, where only Muslim personal laws are codified, a legal officer learned in the Quran and Hadiths is necessary to assist this court or the Supreme Court as well as the Sharia court judges in resolving disputes not involving Muslim personal laws. Next case, whether the Sharia District Court of Marawi City has jurisdiction in an action for recovery of possession filed by Muslim individuals against a municipality whose mayor is a Muslim. This was discussed in the case of Municipality of Tangkal, Lanao del Norte versus Balindong, GR number 193340, January 11, 2017. The facts in this case are as follows. The heirs of the late Macabalo Alompo filed a complaint with the Sharia District Court of Marawi City against the petitioner, Municipality of Tangkal, for recovery of possession and ownership of a parcel of land with an area of approximately 25 hectares located at Barangay Banisilon, Tangkal, Lanao del Norte. They allege that Macalabo was the owner of the land and that in 1962 he entered into an agreement with the Municipality of Tangkal, allowing the latter to borrow the land to pave the way for the construction of the municipal hall and a health center building. The agreement allegedly imposed a condition upon the Municipality of Tangkal to pay the value of the land within 35 years or until 1997. Otherwise, ownership of the land would revert to Macalabo. Private respondents claim that the Municipality of Tangkal neither paid the value of the land within the agreed period nor returned the land to its owner. Thus, they prayed that the land be returned to them as successors in interest of Macalabo. the municipality of Tangkal filed an urgent motion to dismiss on the ground of improper venue and lack of jurisdiction. It argued that since it has no religious affiliation and represents no cultural or ethnic tribe, it cannot be considered a Muslim under the Code of Muslim Personal Laws. Moreover, since the complaint for recovery of land is a real action, it should have been filed in the appropriate regional trial court of Lanao del Norte. So this was the argument of the municipality. The issue in this case is whether the Sharia District Court of Marawi City has jurisdiction in an action for recovery of possession filed by Muslim individuals against a municipality whose mayor is a Muslim. The respondent judge held that it has jurisdiction. What did the Supreme Court say? The Supreme Court held that the matters over which Sharia district courts have jurisdiction are enumerated in the Code of Muslim Personal Laws, specifically Article 143 thereof. So consistent with the purpose of the law to provide for an effective administration and enforcement of Muslim personal laws among Muslims, it has a catch-all provision granting Sharia district courts original jurisdiction over personal and real actions except those for forcible entry and unlawful detainer. The Sharia district court's jurisdiction over these matters is concurrent with regular courts, that is, municipal trial courts and regional trial courts. There is, however, a limit to the general jurisdiction of Sharia district courts over matters ordinarily cognizable by regular courts. What is the limit? Such jurisdiction may only be invoked if both parties are Muslims. If one party is not a Muslim, the action must be filed before the regular courts. So in this case, the complaint, which is a real action involving title to and possession of the land, or in short, real action, was filed by respondents before the Sharia District Court pursuant to the general jurisdiction conferred by Article 143 of the Code of Muslim Personal Laws. In determining whether the Sharia District Court has jurisdiction over the case, the threshold question is whether both parties are Muslims. The Supreme Court held that there is no disagreement that private respondents, as plaintiffs below, are Muslims. The only dispute or question is whether the requirement is satisfied because the mayor of the municipality is also a Muslim. The Supreme Court held that when Article 143 qualifies the conferment of jurisdiction to actions wherein the parties involved are Muslims, the word parties necessarily refers to the real parties in interest. Okay, Section 2 of the Rule 3 of the Rules of Court defines real parties in interest as those who stand to be benefited or injured by the judgment in the suit or are entitled to the avails of the suit. In this case, the parties who will be directly benefited or injured are the private respondents as real party plaintiffs and the municipality of Tangkal as the real party defendant, not the mayor of the municipality. So in their complaint, private respondents claim that their predecessor in interest, Macalabo, entered into an agreement with the municipality of Tangkal for the use of the land. Their cause of action is based on the municipality of Tangkal's alleged failure and refusal to return the land or pay for its reasonable value in accordance with the agreement. So accordingly, they pray for the return of the land or the payment of reasonable rentals thereon. Thus, a judgment in favor of private respondents, either allowing them to recover possession or entitling them to rentals, would undoubtedly be beneficial to them. Correlatively, it would be prejudicial to the municipality of Tangkal, which would either be deprived of possession of the land on which its municipal hall currently stands or be required to allocate funds for payment of rent. Conversely, a judgment in favor of the municipality of Tangkal would effectively quiet its title over the land and defeat the claims of private respondents. Okay, so the Supreme Court held that it is clear from the title and the averments in the complaint that Mayor Batingolo was impleaded only in a representative capacity as chief executive of the local government of Tangkal. When an action is defended by a representative, that representative is not, and neither does he become, a real party in interest. The person represented is deemed the real party in interest, in this case, the municipality of Tangkal. The representative remains to be a third party to the action. That Mayor Batingolo is a Muslim is therefore irrelevant for purposes of complying with the jurisdictional requirement under Article 143(2)(b) that both parties be Muslims. To satisfy the requirement, it is the real party defendant, the municipality of Tangkal, who must be a Muslim. Such a proposition, however, is a legal impossibility. Why? Because the Code of Muslim Personal Laws defines a Muslim as a person who testifies to the oneness of God and the prophethood of Muhammad and professes Islam. Although the definition does not explicitly distinguish between natural and juridical persons, it nonetheless connotes the exercise of religion, which is a fundamental personal right. The ability to testify to the oneness of God and the prophethood of Muhammad and to profess Islam is by its nature restricted to natural persons. In contrast, juridical persons are artificial beings which with no consciences, no beliefs, no feelings, no thoughts, no desires. They are considered persons only by virtue of legal fiction. Okay? It is clear. The municipality of Tangkal falls under this category. Under the Local Government Code, a municipality is a body politic and corporate that exercises powers as a political subdivision of the national government and as a corporate entity representing the inhabitants of its territory. Okay, furthermore, as a government instrumentality, the municipality of Tangkal can only act for secular purposes and in ways that have primarily secular effects, consistent with the Non-Establishment Clause. Hence, even if it is assumed that juridical persons are capable of practicing religion, the municipality of Tangkal is constitutionally proscribed from adopting, much less exercising, any religion, including Islam. The Supreme Court said that the Sharia District Court appears to have understood the foregoing principles as it conceded that the municipality of Tangkal is neither a Muslim nor a Christian. Yet, it still proceeded to attribute the religious affiliation of the mayor to the municipality. So this is a manifest error on the part of the Sharia District Court. It is an elementary principle that a municipality has a personality that is separate and distinct from its mayor, vice mayor, sanggunian, and other officers composing it. And under no circumstances can this corporate veil be pierced on purely religious considerations, as the Sharia District Court has done in this case, without running afoul the inviolability of the separation of church and state enshrined in the Constitution. Alleged as Muslim in the complaint. The case of Montanier v. Sharia District Court, GR number 174975, January 20, 2009. The facts in this case are as follows. Private respondents Liling Disangkopan and her daughter Almalin Liling S. Montanier, both Muslims, filed a complaint for the judicial partition of properties before the Sharia District Court. The said complaint was entitled Almalin Liling S. Montanier and Liling M. Disangkopan versus the estates and properties of late Alejandro Montanier Sr., Luisa Co. Montanier, Lilibeth K. Montanier, Alejandro Co. Montanier Jr. and Rodora Eleanor K. Montanier, and it was docketed as Special Civil Action number 7-05. In the said complaint, private respondents made the following allegations: that in May 1995, Alejandro Montanier Sr. died, that late Alejandro Montanier Sr. is a Muslim, that petitioners are the first family of the decedent, that Liling Di Sangcopan is the widow of the decedent. Petitioners filed an answer with a motion to dismiss, mainly on the ground that the Sharia District Court has no jurisdiction over the estate of the late Alejandro Montanier Sr. because he was a Roman Catholic. The Sharia District Court dismissed the private respondent's complaint. The District Court held that Alejandro Montanier Sr. was not a Muslim, and its jurisdiction extends only to the settlement and distribution of the estate of deceased Muslims. So in its first assailed order, the Sharia District Court reconsidered its order of dismissal. The District Court allowed private respondents to adduce further evidence. In its second assailed order, the Sharia District Court ordered the continuation of trial on the merits, adducement of further evidence, and pre-trial conference. The issue in this case is whether the Sharia District Court of Marawi City has jurisdiction over the case. What do you think? The Supreme Court cited Article 143D of Presidential Decree number 1083, otherwise known as the Code of Muslim Personal Laws of the Philippines. It provides that the Sharia District Court shall have exclusive original jurisdiction over all cases involving disposition, distribution, and settlement of the estate of deceased Muslims, probate of wills, issuance of letters of administration, or appointment of administrators or executors, regardless of the nature or the aggregate value of the property. The court held that although private respondents designated the pleading filed before the Sharia District Court as a complaint for judicial partition of properties, it is actually a petition for the issuance of letters of administration, settlement, and distribution of the estate of the decedent. It contains sufficient jurisdictional facts required for the settlement of the estate of a deceased Muslim, such as the fact of Alejandro Montanier Sr.'s death, as well as the allegation that he is a Muslim. The said petition also contains an enumeration of the names of his legal heirs, so far as known to the private respondents, and a probable list of the properties left by the decedent, which are the very properties sought to be settled before a probate court. Furthermore, the reliefs prayed for reveal that it is the intention of the private respondents to seek judicial settlement of the estate of the decedent. This include the following: number 1, the prayer for the partition of the estate of the decedent, and number 2, the prayer for the appointment of an administrator of the said estate. The Supreme Court held that we cannot agree with the contention of the petitioners that the District Court does not have jurisdiction over the case because of an allegation in their answer with a motion to dismiss that Montanier Sr. is not a Muslim. So remember the rule that jurisdiction of a court over the nature of the action and its subject matter does not depend upon the defenses set forth in an answer or a motion to dismiss. Otherwise, jurisdiction would depend almost entirely on the defendant or result in having a case either thrown out of court or its proceedings unduly delayed by simple stratagem. Indeed, the defense of lack of jurisdiction, which is dependent on a question of fact, does not render the court to lose or be deprived of its jurisdiction. The same rationale applies to an answer with a motion to dismiss. So in the case at bar, the Sharia District Court is not deprived of jurisdiction simply because petitioners raised as a defense the allegation that the deceased is not a Muslim. The Sharia District Court has the authority to hear and receive evidence to determine whether it has jurisdiction, which requires an a priori determination that the deceased is a Muslim. If after hearing the Sharia District Court determines that the deceased was not, in fact, a Muslim, the District Court should dismiss the case for lack of jurisdiction. Let's discuss the issue of support. Mendez v. Sharia District Court, GR number 21614, January 12, 2016. The facts in this case are as follows. On April 9, 2008, Mendez and Maliga were married under Muslim rites. Prior to their marriage, the couple was already blessed with a daughter, Princess Fatima. Their marriage, however, soured shortly after their wedding. On November 2, 2010, Maliga filed with the Sharia Circuit Court a petition for the judicial confirmation of talaq from Mendez. Talaq is divorce effected by the husband. So the petition was filed with a prayer for the grant of probational custody of their minor child pending the resolution of the case. According to Maliga, Mendez was a Roman Catholic and she only embraced the Islamic faith on the date of their marriage. Shortly after being married, he claimed that he started to doubt the sincerity of his wife's submission to Islam, having noticed no changes in her moral attitude and social lifestyle despite his guidance. Maliga added that despite his pleas for her to remain faithful to the ways of Islam, she remained defiant. He alleged that sometime in December 2008, Mendez reverted to Christianity. Maliga went on to add that she went to Manila for a few days after their wedding and brought Princess Fatima with her without his knowledge and consent. In Manila, she taught their daughter how to practice Christianity by enrolling her in a Catholic school. Maliga thus prayed for probational custody, considering, according to him, the unsafe religious growth and values repugnant to Islam. The Sharia Circuit Court awarded the custody to Maliga with the right of visitation to Mendez. Mendez filed a motion for reconsideration of the order, arguing that the question of custody was within the exclusive original jurisdiction of the Sharia District Court and not the Sharia Circuit Court, and praying that the order be declared null and void. The Sharia Circuit Court issued the order confirming the talaq pronounced by Maliga against Mendez, and awarded to him the care and custody of Princess Fatima. In the same order, the Sharia Circuit Court granted visitation rights to Mendez and ordered Maliga to give her a mut'a or consolatory gift in the amount of 24,000. In its ruling, the Sharia Circuit Court noted that Mendez never questioned the validity of the talaq and found that it was caused by the irreconcilable religious differences between the spouses as to the upbringing of their daughter. For said reason, the Sharia Circuit Court ruled that, in the best interest of the child, in all aspects of life, economic, social, and religious, the care and custody of Princess Fatima should remain with Maliga or the father. She asserted that the question of custody again was within the exclusive original jurisdiction of the Sharia District Court only, and that an order of a court not vested with jurisdiction was null and void. The issue in this case is which court has jurisdiction over the custody of the child, the Sharia Circuit Court or the Sharia District Court. The Supreme Court held that at the outset, the court notes that this petition has been correctly instituted with the Supreme Court. It has been recognized that decades after the 1989 enactment of the law creating the Sharia Appellate Court and after the court authorized its creation in 1999, it has yet to be organized. We have discussed this earlier. Pending the organization of the Sharia Appellate Court, appeals or petitions from final orders or decisions of the Sharia District Court shall be filed with the Court of Appeals and referred to a special division to be organized in any of the CA stations, preferably to be composed of Muslim CA justices. Okay, for cases where only errors or questions of law are raised or involved, the appeal shall be to the Supreme Court via petition for review on certiorari under Rule 45 of the Rules of Court. As the present petition involves only questions of law, it has been properly filed with the Supreme Court. The jurisdiction of the Sharia District Courts and Sharia Circuit Courts are provided in PD number 1083. The pertinent articles of the law as to the jurisdiction of the Sharia Courts are as follows: Article 143 for the Sharia District Court and Article 155 for the Sharia Circuit Court. Under Article 143, the Sharia District Court shall have exclusive original jurisdiction over all cases involving custody, guardianship, legitimacy, paternity, and filiation arising under the Code. Under Article 155, the Sharia Circuit Courts shall have exclusive original jurisdiction over all civil actions and proceedings between parties who are Muslims or have been married in accordance with Article 13, involving disputes relating to marriage, divorce recognized under the Code. So it is clear, according to the Supreme Court, that Sharia Circuit Court has exclusive original jurisdiction over civil actions between parties who have been married in accordance with the Muslim law, involving disputes relating to divorce under PD number 1083. There is, therefore, no doubt that the Sharia Circuit Court had jurisdiction to confirm the talaq between Mendez and Maliga. Again, talaq is divorce enforced by the husband. Article 143, however, which describes the jurisdiction of the Sharia District Court, clearly provides that the Sharia District Court has exclusive original jurisdiction over all cases involving custody under PD number 1083. The Sharia Circuit Courts does seem to have ancillary jurisdiction over custody issues as they relate to a divorce decree. Under Article 155, it is provided that the Sharia Circuit Court shall have exclusive original jurisdiction over all civil actions and proceedings involving disputes relating to divorce. Clearly, the provision clothes the Sharia Circuit Court with power to hear and decide civil actions relating to a talaq or divorce. It cannot be denied that the issue of custody is a necessary consequence of a divorce proceeding. So in the same law, Article 54 provides for the effects of irrevocable talaq or fasq. A talaq, as soon as it becomes irrevocable, shall have the following effects. The custody of children shall be determined in accordance with Article 78 of the Code. Okay, though Article 54 does not directly confer jurisdiction to the Sharia Circuit Court to rule on the issue of custody, the court nevertheless grants the Sharia Circuit Court ancillary jurisdiction to resolve issues related to divorce. The quoted provision states categorically that as a consequent effect of divorce, the custody of children shall be determined in accordance with Article 78 of the Code. So in turn, Article 78 states that the care and custody of children below 7 whose parents are divorced shall belong to the mother, and the minor above 7 but below the age of puberty may choose the parent with whom he or she wants to stay. To rule that the Sharia Circuit Court is without jurisdiction to resolve issues in custody after it had decided on the issue of divorce, simply because it appears to contravene Article 143 of PD number 1083, would be antithetical to the doctrine of ancillary jurisdiction. While a court may be expressly granted the incidental powers necessary to effectuate its jurisdiction, a grant of jurisdiction in the absence of prohibitive legislation implies the necessary and usual incidental powers essential to effectuate it, and Subject to existing laws and constitutional provisions, every regularly constituted court has power to do all things that are reasonably necessary for the administration of justice within the scope of its jurisdiction and for the enforcement of its judgments and mandates. Hence, demands, matters, or questions ancillary or incidental to or growing out of the main action, and coming within the above principles, may be taken cognizance of by the court and determined, since such jurisdiction is in aid of its authority over the principal matter, even though the court may thus be called on to consider and decide matters which, as original causes of action, would not be within its cognizance. At this juncture, the question must be asked, by recognizing the power of the Sharia circuit courts to rule on the issue of custody, would this effectively render Article 143 of PD number 1083 meaningless, considering that the same is unequivocal in providing that the Sharia district court has the exclusive original jurisdiction to decide on all cases involving custody? So the court ruled in the negative. The Supreme Court held that a distinction must be made between a case for divorce, wherein the issue of custody is an ancillary issue, and a case where custody is the main issue. Jurisdiction in the former, as discussed, lies with the Sharia circuit court, as the main cause of action is divorce. The latter, on the other hand, where the main cause of action is one of custody, the same must be filed with the Sharia district court pursuant to Article 143 of PD number 1083. Real actions. Villa Gracia versus 5th Sharia District Court, GR number 188832, April 23, 2014. In this case, it involves an action for recovery of possession of real property. The Supreme Court held that under Article 143 of the Muslim Code, the jurisdiction of Sharia district courts over real actions not arising from customary contract is concurrent with that of existing civil courts. However, this concurrent jurisdiction over real actions is applicable solely when both parties are Muslims, as the court held in Tumawis versus Honorable Balindong. So when one of the parties is not a Muslim, the action must be filed before the regular courts. The application of the provisions of the Civil Code of the Philippines by the 5th Sharia District Court does not validate the proceedings before the court. Under Article 175 of the Muslim Code, customary contracts are construed in accordance with Muslim law. Hence, Sharia district courts apply Muslim law when resolving real actions arising from customary contracts. True, no provision in the Code of Muslim Personal Laws of the Philippines expressly prohibits non-Muslims from participating in Sharia court proceedings. So the court held that, in fact, there are instances when provisions in the Muslim Code apply to non-Muslims. Under Article 13, provisions of the Code on Marriage and Divorce apply to the female party in a marriage solemnized according to Muslim law, even if the female is non-Muslim. Under Article 93, Paragraph C, a person of a different religion is disqualified from inheriting from a Muslim decedent. However, by operation of law and regardless of Muslim law to the contrary, the decedent's parent or spouse who is a non-Muslim shall be entitled to 1/3 of what he or she would have received without such disqualification. In these instances, non-Muslims may participate in Sharia court proceedings. Nonetheless, this case does not involve any of the previously cited instances. This case involves an action for recovery of possession of real property. As a matter of law, Sharia district courts may only take cognizance of a real action wherein the parties involved are Muslims. Considering that one of the parties involved in this case is not a Muslim, Respondent Fifth Sharia District Court had no jurisdiction to hear, try, and decide the action for recovery of possession of real property. The judgment against Vivencio is void, for the respondent court lacked jurisdiction over the subject matter of the action. Again, to emphasize on Muslim parties, in the same case of Villagra versus Fifth Sharia District Court, the Supreme Court held that Sharia District Courts have jurisdiction over a real action only when the parties involved are Muslims. Respondent Fifth Sharia District Court acted without jurisdiction in taking cognizance of Roldan y Mala's action for recovery of possession, considering that Vivencio Villagracia is not a Muslim.